How can you request a bail reduction in Oklahoma? I'm Tulsa attorney James Worth. That's the question that we have. You're charged with a criminal offense. Most of the time, it's automatically going to be set for a bond in larger counties like Tulsa County or Oklahoma County through a bond schedule. So that amount is set. But what if you can't afford that amount? Well, you do have the right to request a specific bail hearing for yourself, a specific determination for yourself rather than that general amount in that bond schedule. So you would file a motion for a bond reduction or a motion to determine bond if one isn't set, and that should be quick set before the court, generally within a couple business days. You get before the court. Now, what information do you need to put in that motion? Well, the law, luckily in the state of Oklahoma, is pretty clear. There's a great case on it. So it's Brill v. Gurich. It's 1998 OKCR 49, and it goes over pretty much a summary of the case of the law in Oklahoma regarding bond, and then it goes to the factors to consider for determining bond, which you're going to argue each of those facts on why the bond needs to be reduced. And those are the Humphrey factors from the 1979 court case. But don't worry about reading Humphrey. Everything you need is in that Brill case. So read on that. It talks about the 8 different factors, including seriousness of the crime and apparent likelihood of conviction, your previous criminal history, your reputation and mental condition, the length of your residence in the community, your family ties in the community, your employment status, the identity of responsible members of the community that would vouch for your reliability, and any other factors indicating mode of life or ties to the community. So you're going to want to go through those, see all the factors that most favor you, put those in your motion and argue to get that bail amount reduced. So you can do that at the very beginning of your case. Also, if it's a felony case, you can do that later after you're bound over before your district judge. You can file it at that time. Obviously, the sooner you can get out, then the quicker that you can help in preparing for your defense. So that's generally what you want to do from the defendant's point of view. But if you've got any questions about this, you're dealing with this circumstance, or a friend or family member is, you're going to want to talk to an attorney. You're going to want to get legal advice specific to your circumstances that is actionable for you. To get that scheduled with a lawyer at my office, you can go online to makelawEasy.com.